On April 10, 2019, I submitted writ of habeas corpus pursuant to Title 28 USC 2254 to the United States District Court of Eastern Washington. Included was the responses to the court's Memorandum of Authorities. The court sided with the state in that I was to exhaust state remedies. I clarified to the court that it was inaccurate to say that there was a requirement to exhaust state remedies because remedies have already been foreclosed upon by the petitioner's procedural situation, which waives the requirement for exhausting any more state remedies, because the United States District Court has original jurisdiction of any civil action brought by any person. This was, in fact, civil action. It was within the jurisdiction of the United States, and I was a person, obviously, entitling me the right to be heard by the United States District Court. That statutory obligation was imposed upon the District Court by law, and as a breach of that obligation, it, of course, renders that court in abuse of discretion. This is the letter that was submitted in response to Memorandum of Authorities. It's called the Letter of Consideration. It was the first response that I made to the United States District Court. The petitioner respectfully submits to the court for consideration this petitioner's rebuttal to the respondent's Memorandum of Authority. Petitioners submitted a writ of habeas corpus pursuant to Title 28 USC 2254. This writ of habeas corpus is an original action. It is not a relitigation, an appeal, or mechanism requesting a federal review of petitioner's judgment of conviction. If this were an appeal or a mechanism requesting federal review of judgment of conviction, it would be appropriate for petitioner to exhaust state remedies, as the state has original jurisdiction of the petitioner's judgment and sentence. However, since the petition is a constitutional challenge of the state action, specifically Article 1, Section 26 of the Washington State Constitution, which states no grand jury shall be drawn or summoned in any county except the superior judge thereof shall order, which is unconstitutional on its face and contrary to the clear and unambiguous provisions of Amendment 5 to the United States Constitution, it is necessary to determine what court has jurisdictional authority to oversee the disposition of this matter. In accordance with Title 28 USC 1343, Civil Rights and Elective Franchise, the federal district court has original jurisdiction of his action, as the district court has original jurisdiction of any civil action authorized by law to be commenced by any person. This statute is prescribed to redress the deprivation, under the color of state law, of any right secured by the Constitution of the United States, providing for equal rights of all citizens or of all persons within the jurisdiction of the United States. Petitioner is being denied equal rights under the color of state law. Therefore, as a person bringing this civil action within the jurisdiction of the United States, the district court has original jurisdiction over this matter. As a result, there are no remedies to be exhausted to reach jurisdictional authority for the district court to rule on the merits of this petition. It is undeniable that the United States Constitution is the supreme law of the land. It is undeniable that the United States Constitution enjoys legal superiority over any conflicting provision of a state, constitution, or laws. It is undeniable that the United States Constitution clearly and unambiguously requires an indictment by a grand jury before a person can be held to answer for a capital or infamous crime, and it is undeniable that Article 1, Section 26 of the Washington State Constitution directly and facially violates the laws of the United States and the rights of its citizens. Regardless of the vernacular used, the state has enacted and is enforcing a law that abridges the privileges and immunities of citizens of the United States in violation of the United States Constitution. Therefore, this is a public wrong of constitutional dimension occurring under the color of state law, and federal courts may intervene. Indeed, to preserve the United States Constitution, this court should intervene. Any law that is contrary to the United States Constitution is, by its very nature, unconstitutional and shall not withstand, regardless of how long it's existed or how many times it's been unlawfully applied. Case law is not the supreme law of the land and does not have the authority to alter the provisions of the United States Constitution. America's Constitution is a rigid constitution. It can only be amended by an act of the United States Congress in accordance with Article 5. Neither judge nor state has legal authority to change or violate that which the people have constituted. To date, no amendment to the Fifth Amendment of the United States Constitution has been presented or adopted by the United States Congress. Therefore, petitioner is entitled to the full and equal benefit of the law as a United States citizen, regardless of where within the jurisdiction of the United States he chooses to reside. Since the United States Constitution is an act of Congress, the federal court has the power to grant this writ under Title 28 USC 2241, Sections B, 2, and 3 as 1. Petitioner is in custody for an act omitted in pursuance of an act of Congress of the United States, and 2. Petitioner is in custody in violation of the United States Constitution and the laws of the United States. The grand jury clause of the United States Constitution is an affirmative statute, as it provides positive direction and prescribes what must occur before a person can be held to answer for a capital or infamous crime. The judges in every state, including Washington, refer to Article 6 of the U.S. Constitution and Article 1, Section 28 of the Washington State Constitution, chose to obligate themselves by oath or promise to anything in the Constitution of the United States or laws of any states contrary notwithstanding. As a duty, failure to act willfully or negligently results in a violation of the petitioner's corresponding right to receive the fruits of that obligation. Rights always derive from those duty to act. The citizens of the United States have the right to due process of law because the judges in every state have the duty to ensure that those rights are provided. Duties that are defined affirmatively and applied statutorily are not discretionary. The judges in every state are bound thereby anything in the Constitution or laws of any states contrary notwithstanding. Therefore, Article 1, Section 26 of the Washington State Constitution must be destroyed and preemptively replaced with the correct United States constitutional provision. Imprisonment without legal cause or merely on executive authority is precisely the reason why the writ of habeas corpus was included in American laws dating back to 1628 and taxation without representation. Today, we find conditions and laws in the state of Washington demanding the exercise of this great writ for this purpose in which it was created, and not simply as an appeal for which it was expanded to include. Petitioners being denied equal protection of the law and as equal rights as a United States citizen based solely upon his geographic location with no other reasonable differentiating attribute for such act of deprivation. As a fundamental constitutional right, expressly identified within the Bill of Rights of the United States Constitution, any attempt to deprive petitioner of an indictment by a grand jury before being held to answer for an infamous crime must pass strict scrutiny, and the compelling state interest test must, which to date have not been performed. This is a direct, systemic discrimination of a fundamental right for a suspect classification under the color of state law. Therefore, due process analysis must be performed. The state of Washington has willfully established a class of persons and in turn deprived them of equal rights and protection of the laws guaranteed by the United States Constitution, which is a civil rights violation governed under Title 28 U.S.C. 1343 and the jurisdictional authority of United States District Courts. This violation is contrary to Title 42 U.S.C. Section 1981, which states all persons within the jurisdiction of the United States shall have the same right in every state to the full and equal benefit of all laws and proceedings. The Fifth Amendment is a law of the United States. The grand jury is a proceeding guaranteed by the laws of the United States, and Washington State is subject to the jurisdiction of the United States. Therefore, as a person and citizen of the United States, petitioner is entitled to the full and equal benefit of the Fifth Amendment law and the grand jury proceedings. In accordance with constitutional law, Section 171, state courts are under an obligation to guard and enforce every right secured by the federal Constitution, and the judges in every state are bound by oath or promise to the same obligation. This obligation of the state and of the judges was undeniably breached the moment that the petitioner was held to answer for an infamous crime without having an indictment by a grand jury under the color of state law and in violation of the laws of the United States Constitution. The court refers to Gaines v. Washington as representative case law pertaining to this petition. However, it's worthy to note that Gaines simply makes reference to the state of Washington having provisions in its laws to prosecute with information or indictment as prescribed by law. That provision referenced is actually Article 1, Section 25 of the Washington State Constitution, and petitioners challenging Article 1, Section 26 of the Washington State Constitution, as clearly stated numerous times within the petition. Therefore, Gaines does not apply to this petition as it addresses a different state constitutional provision. Only noncompliance with federal law renders a state criminal judgment susceptible to collateral attack in federal courts. This writ derives precisely from the state's noncompliance with federal law, specifically the United States Constitution, and that noncompliance cannot be disputed because the state has a statute in place which expressly forecloses relief on the merits. In accordance with Title 28 U.S.C. 2254 B1 B II 5F, this is an ineffective corrective process, resulting in a statutory exemption from the exhaustion of state remedies. There is no state remedy because presentation of state court is futile due to the unconstitutional statute, Article 1, Section 26, which expressly forecloses relief on the merits of petitioner's procedural situation. See Clark v. Pennsylvania. Additionally, 28 U.S.C. 2254 does not apply when resorting to them would be ineffective to protect constitutional rights. See Motes v. Leak. The federal constitutional violation is not disputable due to the state's enactment and enforcement of an unconstitutional statute. Petitioners' federally conferred constitutional rights have been violated by the state of Washington, therefore resulting in the state remedies would only lengthen and compound the violation as the state of Washington has already expressly foreclosed relief on the merits of the petitioner's procedural situation. This matter can only be resolved by federal court intervention, upholding the federally conferred constitutional rights of the petitioner and the restoration of federal individual comity for the United States citizen residing within the state of Washington. In conclusion, petitioner asks the court to perform a four corners test on the Constitution to determine the clear answers to the following claims raised within the petitioner's writ of habeas corpus. Number 1, does the United States Constitution allow for any person to be held to answer for an infamous crime without a presentment or indictment of grand jury? Number 2, does the United States Constitution allow for United States citizens residing in one state to be denied rights secured by the United States Constitution and enjoyed by United States citizens residing in other states? Number 3, does the United States Constitution allow for state constitutions to have provisions that are contrary to its provisions? Number 4, Does the United States Constitution allow for states to place United States citizens into involuntary servitude in state-run for-profit industries for the benefit of the state arbitrarily and without complying with the federally established legal processes? Number 5, does the United States Constitution allow for states to enact and enforce laws that abridge the privileges and immunities of citizens of the United States? Number 6, does the United States Constitution permit changes or amendments to its provisions in any manner other than an act of Congress approved by the United States, the people of the United States? In 1858, President Abraham Lincoln delivered to the nation words that are quite fitting to close this rebuttal, and on the heels of the 243rd anniversary of the signing of our nation's Declaration of Independence, the wisdom contained in these words are needed of application today. In the founders' lightened belief, nothing stamped with the divine image and likeness was sent into the world to be trodden upon or degraded or imbued by its fellow. They grasped not only the whole race of man then living, but they reached forward and seized upon the furthest posterity. They erected a beacon to guide their children and their children's children and the countless myriads who should inhabit the earth in other ages. Wise statesmen as they were, they knew the tendency of prosperity to breed tyrants, and so they established these great self-evident truths that when in the distant future some men, some faction, some interest should set up the doctrine that none but rich men or none but white men were entitled to life, liberty, and the pursuit of happiness, their posterity might look up again to the Declaration of Independence and take courage to renew the battle which their fathers began, so that truth, justice, and mercy, and all the human and Christian virtues might not be extinguished from the land, so that no man would hereafter dare to limit and circumscribe the great principles upon which the Temple of Liberty was being built. God bless this court, and God bless America. Respectfully and peacefully, a servant of justice, Tanoa M. Downing.